Hello and welcome back to the chapter number 8, that is DPSP, Directive Principles of State Policy. The DPSP are enumerated in Part 4 of the Constitution from Articles 36 to 51. The framers of the Constitution borrowed this idea from the Irish Constitution of 1937, which had copied it from the Spanish Constitution. Dr. B.R. Ambedkar described these principles as novel features of the Indian Constitution. The directive principles, along with the fundamental rights, contain the philosophy of the Constitution and is the soul of the Constitution. Grenville Austin has described the directive principles and the fundamental rights as the conscience of the Constitution. तो इसीलिए हम फंडामेंटल राइट्स पढ़ने के बाद ये वाला चैप्टर पढ़ रहे हैं. Features of the Directive Principles. The phrase Directive Principles of State Policy denotes the ideals that the state should keep in mind while formulating policies and enacting laws. These are the constitutional instructions or recommendations to the state in legislative, executive, and administrative matters. According to Article 36, the term state in Part 4 has the same meaning as in Part 3 dealing with fundamental rights. Therefore, it includes the legislative and executive organs of the central and state governments, all local authorities, and all other public authorities in the country. The directive principles resemble the instrument of instructions enumerated in the Government of India Act of 1935. In the words of Dr. B.R. Ambedkar, the directive principles are like the instrument of instructions which were issued to the Governor General and to the governors of the colonies of India by the British government under the Government of India Act of 1935. What is called directive principles is merely another name for the instrument of instructions. The only difference is that they are instructions to the legislature and the executive. The directive principles constitute a very comprehensive economic, social, and political program for a modern democratic state. They aim at realizing the high ideals of justice, liberty, equality, and fraternity as outlined in the preamble to the Constitution. They embody the concept of a welfare state and not that of a police state, which existed during the colonial era. In brief, they seek to establish economic and social democracy in the country. The directive principles are non-justiciable in nature, that is, they are not legally enforceable by the courts for their violation. Therefore, the government, central, state, and local, cannot be compelled to implement them. Nevertheless, the Constitution, Article 37 itself says that these principles are fundamental in the governance of the country, and it shall be the duty of the state to apply these principles in making laws. The directive principles, though non-justiciable in nature, help the courts in examining and determining the constitutional validity of a law. The Supreme Court has ruled many a times that in determining the constitutionality of any law, if a court finds that the law in question seeks to give effect to a directive principle, it may consider such law to be reasonable in relation to Article 14, equality before law, or Article 19, 6 freedoms, and thus save such law from unconstitutionality. Classification of the directive principles. The Constitution does not contain any classification of directive principles. However, on the basis of their content and direction, they can be classified into three broad categories, which socialistic, Gandhian, and liberal intellectual. Socialistic principles. These principles reflect the ideology of socialism. They lay down the framework of a democratic socialist state aimed at providing social and economic justice and set the path towards welfare state. They direct the state to promote the welfare of the people by securing a social order permeated by justice, social, economic, and political, and to minimize inequalities in income, status, facilities, and opportunities. Article 38. To secure the right to adequate means of livelihood for all citizens, the equitable distribution of material resources of the community for the common good, prevention of concentration of wealth and means of production, equal pay for equal work for men and women, preservation of the health and strength of workers and children against forcible abuse, and opportunities for healthy development of children. Article 39. To promote equal justice and to provide free legal aid to the poor. Article 39A. To secure the right to work, to education, and to public assistance in cases of unemployment, old age, sickness, and disablement. Article 41. To make provision for just and human conditions of work and maternity relief. Article 42. To secure a living wage, a decent standard of life, and social and cultural opportunities for all workers. Article 43. To take steps to secure the participation of workers in the management of industries, yeah, industries मतलब अच्छा industries. Article 43A. To raise the level of nutrition and the standard of living of people and to improve public health ये article 47 में दिएगा. Now Gandhian principles. These principles are based on Gandhian ideology. They represent the program of reconstruction enunciated by Gandhian during the national movement. In order to fulfill the dreams of Gandhi, some of his ideas were included as directive principles. They require the state to organize village panchayats and endow them with necessary powers and authority to enable them to function as units of self-government. Article 40. To promote cottage industries on an individual or cooperation basis in rural areas. Article 43. To promote voluntary formation, autonomous functioning, democratic control, and professional management of cooperative societies. Article 43b. To promote the educational and economic interests of SCs, STs, and other weaker sections of the society, and to protect them from social injustice and exploitation. Article 46. To prohibit the consumption of intoxicating drinks and drugs which are injurious to health. Article 47. To prohibit the slaughter of cows, calves, and other milch and brought cattle, and to improve their breeds. Article 48. Then liberal intellectual principles. The principles included in this category represent the ideology of liberalism. They direct the state to secure for all citizens a uniform civil code throughout the country. Article 44. To provide early childhood care and education for all children until they complete the age of 6 years. Article 45. To organize agriculture and animal husbandry on modern and scientific lines. Article 48. To protect and improve the environment and to safeguard forests and wildlife. Article 48A. To protect monuments, places, and objects of artistic or historic interest which are declared to be of national importance. Article 49. To separate the judiciary from the executive in the public services of the state. Article 50. To promote international peace and security and maintain just and honorable relations between nations, to foster respect for international law and treaty obligations, and to encourage settlement of international disputes by arbitration. That is Article 51. New directive principles. The 42nd Amendment Act of 1976 added 4 new directive principles to the original list. They require the state to secure opportunities for healthy development of children. Article 39. To promote equal justice and to provide free legal aid to the poor. Article 39A. To take steps to secure the participation of workers in the management of industries. Article 43A. To protect and improve the environment and to safeguard forests and wildlife. Article 48A. The 44th Amendment Act of 1978 added one more directive principle which requires the state to minimize inequalities in income, status, facilities, and opportunities. Article 38. The 86th Amendment Act of 2002 changed the subject matter of Article 45 and made elementary education a fundamental right under Article 21A. The amended directive requires the state to provide early childhood care and education for all children until they complete the age of 6 years. The 97th Amendment Act of 2011 added a new directive principle relating to cooperative societies. It requires the state to promote voluntary formation, autonomous functioning, democratic control, and professional management of cooperative society. Article 43b. Sanction behind directive principles. Sir B. N. Rao, the constitutional advisor to the Constituent Assembly, recommended that the rights of an individual should be divided into two categories, justiciable and non-justiciable, which was accepted by the drafting committee. Consequently, the fundamental rights which are justiciable in nature are incorporated in Part 3, and the directive principles which are non-justiciable in nature are incorporated in Part 4 of the Constitution. Though the directive principles are non-justiciable, the Constitution Article 37 makes it clear that these principles are fundamental in the governance of the country, and it shall be the duty of the state to apply these principles in making laws. Thus, they impose a moral obligation on the state authorities for their application, but the real force behind them is political, that is, public opinion. As observed by Aladi Krishnaswamy Iyer, no ministry responsible to the people can afford light-heartedly to ignore the provisions in Part 4 of the Constitution. Similarly, Dr. B.R. Ambedkar said in the Constituent Assembly that a government which rests on popular vote can hardly ignore the directive principles while shaping its policy. If any government ignores them, it will certainly have to answer for that before the electorate at the election time. The framers of the Constitution made the directive principles non-justiciable and legally non-enforceable because the country did not possess sufficient financial resources to implement them. The presence of vast diversity and backwardness in the country would stand in the way of their implementation. The newly born independent Indian state, with its many preoccupations, might be crushed under the burden unless it was free to decide the order, the time, the place, and the mode of fulfilling them. The constitution makers, therefore, taking a pragmatic view, refrained from giving teeth to these principles. They believed more in an awakened public opinion rather than in court procedures as the ultimate sanction for the fulfillment of these principles. Criticism of the directive principles. The directive principles of state policy have been criticized by some members of the Constituent Assembly as well as other constitutional and political experts on the following grounds. No legal force. The directives have been criticized mainly because of their non-justiciable character, while Katie Shah dubbed them as pious superfluities and compared them with a check on a bank payable only when the resources of the bank permit. Nasiruddin contended that these principles are no better than the New Year's resolutions which are broken on the 2nd of January. Even as D.T. Krishnamachari described the directives as a veritable dustbin of sentiments. Casey Ware called them as manifesto of aims and aspirations and opined that they serve as mere moral homily, and Sir Ivor Jennings thought they are only as pious aspirations. Illogically arranged. Critics opine that the directives are not arranged in a logical manner based on a consistent philosophy. According to N. Srinivasan, the directives are neither properly classified nor logically arranged. The declaration mixes up relatively unimportant issues with the most vital economic and social questions. It combines rather incongruously the modern with the old, and provisions suggested by the reason and science with provisions based purely on sentiment and prejudice. Sir Ivor Jennings too pointed out that these principles have no consistent philosophy. Conservative. According to Sir Ivor Jennings, the directives are based on the political philosophy of the 19th century England. He remarked the ghosts of Sidney Webb and Beatrice Webb stalk through the pages of the text. Part 4 of the Constitution expresses Fabian socialism without the socialism. He opined that the directives are deemed to be suitable in India in the middle of the 20th century. The question whether they are suitable for the 21st century cannot be answered, but it is quite probable that they will be entirely outmoded. Constitutional conflict. K. Santhanam has pointed out that the directives lead to a constitutional conflict between the center and the states, between the president and the prime minister, and between the governor and the chief minister. According to him, the center can give directions to the states with regard to the implementation of these principles, and in case of non-compliance can dismiss the state government. Similarly, when the prime minister gets a bill which violates the directive principle passed by the parliament, the president may reject the bill on the ground that these principles are fundamental to the governance of the country and hence the ministry has no right to ignore them. The same constitutional conflict may occur between the governor and the chief minister at the state level. Utility of directive principles. In spite of the above criticisms and shortcomings, the directive principles are not an unnecessary appendage to the Constitution. The Constitution itself declares that they are fundamental to the governance of the country. According to L.M. Singhvi, an eminent jurist and diplomat, the directives are the life-giving provisions of the Constitution. They constitute the staff of the Constitution and its philosophy of social justice. M.C. Chagla, former Chief Justice of India, is of the opinion that if all these principles are fully carried out, our country would indeed be a heaven on earth. India would then be not only democracy in the political sense but also a welfare state looking after the welfare of its citizens. Dr. B.R. Ambedkar had pointed out that the directives have great value because they lay down that the goal of Indian polity is economic democracy as distinguished from political democracy. Grenville Austin opined that the directive principles are aimed at furthering the goals of the social revolution or to foster this revolution by establishing the conditions necessary for its achievement. Sir B.N. Rao, the constitutional advisor to the Constituent Assembly, stated that the directive principles are intended as moral precepts for the authorities of the state. They have at least an educative value. According to M.C. Settlewad, the former Attorney General of India, the directive principles, although confer no legal rights and create no legal remedies, are significant and useful in the following ways. They are like an instrument of instruction or general recommendations addressed to all authorities in the Indian Union. They remind them of the basic principles of the new social and economic order which the Constitution aims at building. They have served as useful beacon lights to the courts. They have helped the courts in exercising their power of judicial review, that is, the power to determine the constitutional validity of a law. They form the dominating background to all state action, legislative or executive, and also a guide to the courts in some respects. They amplify the preamble, which solemnly resolves to secure to all citizens of India justice, liberty, equality, and fraternity. The directives also play the following roles. They facilitate stability and continuity in domestic and foreign policies in political, economic, and social spheres in spite of the changes of the party in power. They are supplementary to the fundamental rights of the citizens. They are intended to fill in the vacuum in Part 3 by providing for social and economic rights. Their implementation creates a favorable atmosphere for the full and proper enjoyment of the fundamental rights by the citizens. Political democracy without economic democracy has no meaning. They enable the opposition to exercise influence and control over the operations of the government. The opposition can blame the ruling party on the ground that its activities are opposed to the directives. They serve as a crucial test for the performance of the government. The people can examine the policies and programs of the government in the light of these constitutional declarations. They serve as common political manifesto. A ruling party, irrespective of its political ideology, has to recognize the fact that these principles are intended to be its guide, philosopher, and friend and in its legislative and executive acts. Conflict between fundamental rights and directive principles. The justiciability of fundamental rights and non-justiciability of directive principles on the one hand and the moral obligation of state to implement directive principles, Article 37, on the other hand, have led to a conflict between the two since the commencement of the Constitution. In the Champakam Dorairajan case 1951, the Supreme Court ruled that in case of any conflict between the fundamental rights and the directive principles, the former would prevail. It declared that the directive principles have to conform to and run as subsidiary to the fundamental rights, but it also held that the fundamental rights could be amended by the Parliament by enacting Constitutional Amendment Acts. As a result, the Parliament made the First Amendment Act, the Fourth Amendment Act, the 17th Amendment Act to implement some of the directives. The above situation underwent a major change in 1967 following the Supreme Court's judgment in the Goloknath case. In that case, the Supreme Court ruled that the Parliament cannot take away or abridge any of the fundamental rights which are sacrosanct in nature. In other words, the court held that the fundamental rights cannot be amended for the implementation of the directive principles. The Parliament reacted to the Supreme Court's judgment in the Goloknath case by enacting the 24th Amendment Act 1971 and the 25th Amendment Act 1971. The 24th Amendment Act declared that the Parliament has the power to abridge or take away any of the fundamental rights by enacting constitutional amendment acts. The 25th Amendment Act inserted a new Article 31C which contained the following two provisions: no law which seeks to implement the socialistic directive principles specified in Article 39B and C shall be void on the ground of contravention of the fundamental rights conferred by Article 14, equality before law and equal protection of laws, Article 19, protection of six rights in respect of speech, assembly, movement, etc., or Article 31, right to property. No law containing a declaration for giving effect to such policy shall be questioned in any court on the ground that it does not give effect to such a policy. In the Kesavanand Bharti case 1973, the Supreme Court declared the above second provision of Article 31C as unconstitutional and invalid on the ground that judicial review is a basic feature of the Constitution and hence cannot be taken away. However, the above first provision of Article 31C was held to be constitutional and valid. Distinction between fundamental rights and directive principles. Fundamental rights versus directive principles. These are negative as they prohibit the state from doing certain things. These are positive as they require the state to do certain things. These are justiciable, that is, they are legally enforceable by the courts in case of their violation. Directive principles, these are non-justiciable, that is, they are not legally enforceable by the courts for their violation. They aim at establishing political democracy in the country. They aim at establishing social and economic democracy in the country. These have legal sanctions. These have moral and political sanctions. And fundamental rights are negative as they prohibit the state from doing certain things. Directive principles are positive as they require the state to do certain things. Okay. Now efforts are justiciable, that is, they are legally enforceable by the courts in case of their violation, and DPs are non-justiciable, that is, they are not legally enforceable by the courts for their violation. Efforts aim at establishing political democracy in the country, whereas DPs aim at establishing social and economic democracy in the country. Then efforts have legal sanctions, whereas DPs have moral and political sanctions. Efforts promote the welfare of the individual, hence they are personal and individualistic, whereas DP promote the welfare of the community, hence they are societarian and socialistic. Then effort do not require any legislation for their implementation, they are automatically enforced, whereas DP require legislation for their implementation, they are not automatically enforced. Efforts, the courts are bound to declare a law violative of any of the fundamental rights as unconstitutional and invalid. The DP, in case of DP, the courts cannot declare a law violative of any of the DPs as unconstitutional and invalid. However, they can uphold the validity of a law on the ground that it was enacted to give effect to a directive. Later, the 42nd Amendment Act 1976 extended the scope of the above first provision of Article 31C by including within its protection by any law to implement any of the directive principles and not merely those specified in Article 31B and C. In other words, the 42nd Amendment Act accorded the position of legal primacy and supremacy to the directive principles over the fundamental rights conferred by Articles 14, 19 and 31. However, this extension was declared as unconstitutional and invalid by the Supreme Court in the Minerva Mills case 1980. It means that the directive principles are once again made subordinate to the fundamental rights, but the fundamental rights conferred by Article 14 and Article 19 were accepted as subordinate to the directive principles specified in Article 39B and C. Further, Article 31, right to property, was abolished by the 44th Amendment Act 1978. In the Minerva Mills case 1980, the Supreme Court also held that the Indian Constitution is founded on the bedrock of the balance between the fundamental rights and the directive principles. They together constitute the core of commitment to social revolution. They are like two wheels of a chariot, one no less than the other. To give absolute primacy to one over the other is to disturb the harmony of the Constitution. This harmony and balance between the two is an essential feature of the basic structure of the Constitution. The goals set out by the directive principles have to be achieved without the abrogation of the means provided by the fundamental rights. Therefore, the present position is that The fundamental rights enjoy supremacy over the directive principles. Yet, this does not mean that the directive principles cannot be implemented. The Parliament can amend the fundamental rights for implementing the directive principles, so long as the amendment does not damage or destroy the basic structure of the Constitution. तो ये लाइन बहुत इंपॉर्टेंट है. Now, implementation of directive principles. Since 1950, the successive governments at the center and in the states have made several laws and formulated various programs for implementing the directive principles. These are mentioned below. The Planning Commission was established in 1950 to take up the development of the country in a planned manner. The successive 5-year plans aimed at securing socio-economic justice and reducing inequalities of income, status and opportunities. In 2015, the Planning Commission was replaced by a new body called Niti Aayog, National Institution for Transforming India. Niti का full form. Almost all the states have passed land reform laws to bring changes in the agrarian society and to improve the conditions of the rural masses. These measures include abolition of intermediaries like jamindars, jagirdars, inamdars, etc., tenancy reforms like security of tenure, fair rents, etc., imposition of ceilings on land holdings, distribution of surplus land among the landless laborers, and cooperative farming. The Minimum Wages Act 1948, the Payment of Wages Act 1936, the Payment of Bonus Act 1965, the Contract Labor Regulation and Abolition Act 1970, the Child Labor Prohibition and Regulation Act. ये सारे लॉज इस पर DPSP के अंदर लिया गया था. ठीक है. द मैटरनिटी बेनिफिट एक्ट एंड द इक्वल रेम्यूनरेशन एक्ट, ये सब सारे जितने भी लिया जाएगा. Then various measures have been taken to utilize the financial resources for promoting the common good. These include nationalization of life insurance, the nationalization of 14 leading commercial banks, nationalization of general insurance, abolition of privy purses, and so on. The Legal Services Authorities Act has established a nationwide network to provide free and competent legal aid to the poor and to organize Lok Adalat for promoting equal justice. Lok Adalat is a statutory form, इसके बारे में पढ़ लिया हमने. For conciliatory settlement of legal disputes, it has been given the status of a civil court. Its awards are enforceable, binding on the parties, and final as no appeal lies before any court against them. Khadi and Village Industries Board, Khadi and Village Industries Commission, Small Scale Industries Board, National Small Industries Corporation, Handloom Board, Handicrafts Board, Coir Board, Silk Board, and so on have been set up for the development of cottage industries in rural areas. The Community Development Program 1952, Hill Area Development Program 1960, Drought Prone Area Program 1973, Minimum Needs Program 1974, Integrated Rural Development Program 1978, Jawahar Rozgar Yojana 1989, then Swarno Jayanti Gram Swarojgar Yojana 1999. These are laws for raising the standard of living of people. Then Wildlife Protection Act, Forest Conservation Act, ये सब enacted to safeguard the wildlife and the forest respectively. Further, the Water and Air Acts have provided for the establishment of the central and state pollution control boards, which are engaged in the protection and improvement of environment. The National Forest Policy 1988 aims at the protection, conservation, and development of forests. Agriculture has been modernized by providing improved agricultural inputs, seeds, fertilizers, and irrigation facilities. Various steps have also been taken to organize animal husbandry on modern and scientific lines. 3-tier Panchayati Raj system at village, taluka, and jila levels has been introduced to translate into reality Gandhiji's dream of every village being a republic. The 73rd Amendment Act has been enacted to provide constitutional status and protection to these Panchayati Raj institutions. Seats are reserved for SCs, STs, and other weaker sections in educational institutions, government services, and representative bodies. The Untouchability Act 1955, which was renamed as the Protection of Civil Rights Act in 1976. Various national level commissions have been established to promote and protect the social, educational, and economic interest of the weaker sections of the society. Then in 2019 the central government issued orders. इतने इंपॉर्टेंट है नहीं इसलिए मैं ये सब पढ़ नहीं रहा हूँ, एक्ट वगैरह स्किप कर रहा हूँ. ठीक है. In 2019 the central government issued orders providing 10% reservation to the economically weaker sections इन एडमिशन टू एजुकेशनल इंस्टीट्यूशंस, ऑलरेडी हमने पढ़ा है, एंड सिविल पोस्ट एंड सर्विसेज इन द गवर्नमेंट ऑफ इंडिया, चलो इसको हटाओ। द क्रिमिनल प्रोसीड्यूर कोड 1973 separated the judiciary from the executive in the public services of the state. Prior to the separation, the district authority like the collector, the subdivisional officer, the tehsildar and so on used to exercise judicial powers along with the traditional executive powers. तो पहले अच्छा ये डिस्ट्रिक्ट ऑथोरिटी लाइक कलेक्टर मतलब डीएम, इसके हाथ जुडिशल पावर था, बट अभी नहीं है, ठीक है, 1973 के बाद। आफ्टर द सेपरेशन द जुडिशियल पावर्स आर टेकन अवे फ्रॉम द एग्जीक्यूटिव अथॉरिटीज एंड वेस्टेड इन द हैंड्स ऑफ डिस्ट्रिक्ट जुडिशियल मैजिस्ट्रेट्स हु वर्क अंडर द डायरेक्ट कंट्रोल ऑफ द स्टेट हाई कोर्ट। तो ये देखो डीएम मतलब डिस्ट्रिक्ट मैजिस्ट्रेट बोला जाता है, और यहाँ पर है डिस्ट्रिक्ट जुडिशियल मैजिस्ट्रेट, तो दोनों अलग है ना, आई थिंक सो। The Ancient and Historical Monument and Archaeological Sites and Remains Act 1951 has been enacted to protect the monuments, places and objects of national importance. Primary health centers and hospitals have been established throughout the country to improve the public health. Also, special programs have been launched to eradicate widespread diseases like malaria, TB, leprosy, AIDS, cancer, filaria, kalajor, then guinea worm, yawas, Japanese encephalitis and so on. Laws to prohibit the slaughter of cows, calves and blocks have been enacted in some states. Some states have initiated the old age pension schemes for people above 65 years. India has been following the policy of non-alignment and punch seal to promote international peace and security. In spite of the above states by the central and state governments, the directive principles have not been implemented fully and effectively due to several reasons like inadequate financial resource, unfavorable socio-economic condition, population explosion, strained center-state relations and so on. Now directive is outside part 4. Apart from the directives included in part 4, there are some other directives contained in other parts of the constitution. They are claims of SCs and STs to services. The claims of the members of the scheduled caste and scheduled tribes shall be taken into consideration consistently with the maintenance of efficiency of administration in the making of appointments to services and posts in connection with the affairs of the union or state. Article 335 in part 16. Instruction in mother tongue. It shall be the endeavor of every state and every local authority within the state to provide adequate facilities for instruction in the mother tongue at the primary stage of education to children belonging to linguistic minority groups. Article 350A in part 17. Development of the Hindi language. It shall be the duty of the union to promote the spread of the Hindi language and to develop it so that it may serve as a medium of expression for all the elements of the composite culture of India. Article 351 in part 17. The above directives are also non-justiciable in nature. However, they are also given equal importance and attention by the judiciary on the ground that all parts of the constitution must be read together. So 3 एक्स्ट्रा है डायरेक्टिव आउटसाइड पार्ट 4 जो है क्लेम्स ऑफ SCs STs टू सर्विसेज, इंस्ट्रक्शन इन मदर टंग एंड डेवलपमेंट ऑफ द हिंदी लैंग्वेज। ठीक है, तो यहाँ पर ये चैप्टर खत्म होता है, ये आर्टिकल का लिस्ट है। चलिए हम नेक्स्ट चैप्टर जाएंगे फंडामेंटल ड्यूटीज के बारे में। तो ये लगभग 7 पेजेस का है ये चैप्टर, तो थोड़ी रेस्ट लेने के बाद इसको मैं कंटिन्यू करता हूँ। ओके, सो बैक after a छोटी सी break. So this is chapter number 9. It is about fundamental duties. Though the rights and duties of the citizens are correlative and inseparable, the original constitution contained only the fundamental rights and not the fundamental duties. In other words, the framers of the constitution did not feel it necessary to incorporate the fundamental duties of the citizens in the constitution. However, they incorporated the duties of the state in the constitution in the form of directive principles of state polity. देखो पॉलिटी लिखता है, स्टेट पॉलिसी होगा ना भाई। Later in 1976, the fundamental duties of citizens were added in the constitution. तो ये फंडामेंटल ड्यूटीज 1976 में ऐड हुआ था, बहुत इंपॉर्टेंट है। In 2002, one more fundamental duty was added. ठीक है, तो 1976 में कितना था वो यहाँ पर बताया नहीं गया, देखते हैं। द फंडामेंटल ड्यूटीज इन द इंडियन कॉन्स्टिट्यूशन आर इंस्पायर्ड बाय द कॉन्स्टिट्यूशन ऑफ आर्ट्स टू हाईली वैसेस आर नोटेबली none of the constitution of major democratic countries like USA, Canada, France, Germany, Australia and so on specifically contain a list of duties of citizens. Japanese constitution is perhaps the only democratic constitution in the world which contains a list of duties of citizens. The socialist countries of the country on the contrary, gave equal importance to the fundamental rights and duties of their citizens. Hence, the Constitution of erstwhile USSR declared that the citizens' exercise of their rights and freedoms was inseparable from the performance of their duties and obligations. Saran Singh Committee recommendations. In 1976, the Congress Party set up the Sardar Saran Singh Committee to make recommendations about fundamental duties, the need and necessity of which was felt during the operation of the internal emergency 1975 to 77. The committee recommended the inclusion of a separate chapter on fundamental duties in the Constitution. It stressed that the citizens should become conscious that in addition to the enjoyment of rights, they also have certain duties to perform as well. The Congress government at center accepted these recommendations and enacted the 42nd Constitutional Amendment Act in 1976. This amendment added a new part, namely Part 4A to the Constitution. This new part consists of only one article, that is Article 51A, which for the first time specified a code of 10 fundamental duties of the citizens. The ruling Congress party declared the non-inclusion of fundamental duties in the Constitution as a historical mistake and claimed that what the framers of the Constitution failed to do was being done now. Though the Saran Singh Committee suggested the incorporation of 8 fundamental duties in the Constitution, the 42nd Amendment Act included 10 fundamental duties. Interestingly, certain recommendations of the committee were not accepted by the Congress party and hence not incorporated in the Constitution. These include: the Parliament may provide for the imposition of such penalty or punishment as may be considered appropriate for any non-compliance with or refusal to observe any of the duties. Then, no law imposing such penalty or punishment shall be called in question in any court. ऐसा कैसे हो सकता है भाई? ये सब कैसी गंदी गंदी recommendation दिया था. Or infringement of any fundamental rights or on the ground of repugnancy to any other provision of the Constitution. Duty to pay taxes should also be a fundamental duty of the citizens. List of fundamental duties. According to Article 51A, it shall be the duty of every citizen of India to abide by the Constitution and respect its ideals and institutions, the national flag and national anthem, to cherish and follow the noble ideals that inspired the national struggle for freedom, to uphold and protect the sovereignty, unity and integrity of India, to defend the country and render national service when called upon to do so, to promote harmony and the spirit of common brotherhood amongst all the people of India, transcending religious, linguistic and regional or sectional diversities, and to renounce practices derogatory to the dignity of women, to value and preserve the rich heritage of the country's composite culture, to protect and improve the natural environment including forests, lakes, rivers and wildlife, and to have compassion for living creatures, to develop scientific temper, humanism and the spirit of inquiry and reform, to safeguard public property and to abjure violence, to strive towards excellence in all spheres of individual and collective activity so that the nation constantly rises to higher levels of endeavor and achievement, and to provide opportunities for education to his child or ward between the age of 6 and 14 years. This duty was added by the 86th Constitutional Amendment Act 2002. तो ये देखो 11 fundamental duty हो गया. Features of the fundamental duties. Following points can be noted with regard to the characteristics of the fundamental duties. Number 1. Some of them are moral duties while others are civil duties. For instance, cherishing noble ideals of freedom struggle is a moral precept, and respecting the Constitution, national flag and national anthem is a civic duty. They refer to such values which have been a part of the Indian tradition, mythology, religions and practices. In other words, they essentially contain just a codification of tasks integral to the Indian way of life. Unlike some of the fundamental rights which extend to all persons, whether citizens or foreigners, the fundamental duties are confined to citizens only and do not extend to foreigners. Like the directive principles, the fundamental duties are also non justiciable. The Constitution does not provide for their direct enforcement by the courts. Moreover, there is not legal sanction against their violation. However, the Parliament is free to enforce them by suitable legislation. Criticism of fundamental duties. The fundamental duties mentioned in Part 4A of the Constitution have been criticized on the following grounds. The list of duties is not exhaustive as it does not cover other important duties like casting vote, paying taxes, family planning, and so on. In fact, duty to pay taxes was recommended by the Saran Singh Committee. Some of the duties are vague, ambiguous, and difficult to be understood by the common man. For example, different interpretation can be given to the pressure like noble ideals, composite culture, scientific temper, and so on. हाँ ये बात तो है. They have been described by the critics as a code of moral precepts due to their non-justiciable character. Interestingly, the Soren Singh committee had suggested for penalty or punishment for the non-performance of fundamental duties. Their inclusion in the constitution was described by the critics as superfluous. This is because the duties included in the constitution as fundamental would be performed by the people even though they are not incorporated in the constitution. The critics said the inclusion of fundamental duties as an appendage to part 4 of the constitution has reduced their value and significance. They should have been added after part 3 so as to keep them on par with fundamental rights. Significance of fundamental duties. In spite of criticism and opposition, the fundamental duties are considered significant from the following viewpoints. They serve as a reminder to the citizens that while enjoying their rights, they should also be conscious of duties they owe to their country, their society, and to their fellow citizens. They serve as a warning against the anti-national and anti-social activities like burning the national flag, destroying public property, and so on. They serve as a source of inspiration for the citizens and promote a sense of discipline and commitment among them. They create a feeling that the citizens are not mere spectators but active participants in the realization of national goals. They help the courts in examining and determining the constitutional validity of a law. In 1992, the Supreme Court ruled that in determining the constitutionality of any law, if a court finds that the law in question seeks to give effect to a fundamental duty, it may consider such law to be reasonable in relation to Article 14, equality before law, or Article 19, 6, freedoms, and thus save such law from unconstitutionality. They are enforceable by law, hence the Parliament can provide for the imposition of appropriate penalty or punishment for failure to fulfill any of them. H.R. Gokhale, the then law minister, gave the following reason for incorporating the fundamental duties in the Constitution after 26 years of its inauguration. In post-independent India, particularly on the eve of emergency in June 1975, a section of the people showed no anxiety to fulfill their fundamental obligations of respecting the established legal order. The provisions of chapter on fundamental duties would have a sobering effect on these restless spirits who have had a host of anti-national, subversive, and unconstitutional agitations in the past. Indira Gandhi, the then Prime Minister, justified the inclusion of fundamental duties in the Constitution and argued that their inclusion would help to strengthen democracy. She said the moral value of fundamental duties would be not to smooth their rights but to establish a democratic balance by making the people conscious of their duties equally as they are conscious of their rights. The opposition in the parliament strongly opposed the inclusion of fundamental duties in the constitution by the Congress government. However, the new Janata government headed by Morarji Desai in the post-emergency period did not annul the fundamental duties. Notably, the new government sought to undo many changes introduced in the constitution by the 42nd Amendment Act through the 43rd Amendment Act 1977 and the 44th Amendment Act 1978. This shows that there was an eventual consensus on the necessity and desirability of including the fundamental duties in the Constitution. This is more clear with the addition of one more fundamental duty in 2002 by the 86th Amendment Act. Burma Committee Observation. The Burma Committee of Fundamental Duties of the Citizens 1999 identified the existence of legal provisions for the implementation of some of the fundamental duties. They are mentioned below. The Prevention of Insults to National Honor Act 1971 prevents disrespect to the Constitution of India, the national flag, and the national anthem. The various criminal laws in force provide for punishments for encouraging enmity between different sections of people on grounds of language, race, place of birth, religion, and so on. The Protection of Civil Rights Act 1955 provides for punishments for offences related to caste and religion. The Indian Penal Code (IPC) declares the imputations and assertions prejudicial to national integration as punishable offences. The Unlawful Activities Prevention Act of 1967 provides for the declaration of a communal organization as an unlawful association. The Representation of People Act 1951 provides for the disqualification of members of the parliament or state legislature for indulging in corrupt practice, that is, soliciting votes on the ground of religion or promoting enmity between different sections of people on grounds of caste, race, language, religion, and so on. The Wildlife Protection Act of 1972 prohibits trade in rare and endangered species. The Forest Conservation Act of 1980 checks indiscriminate deforestation and a diversion of forest land for non-forest purposes. तो ये था हमारा फंडामेंटल ड्यूटीज़ वाला चैप्टर। अब हमको पढ़ना है इमरजेंसी प्रोविजंस के बारे में, जो है हमारा चैप्टर नंबर 16। तो चलते हैं, तो हम इसे स्टार्ट करेंगे छोटी सी ब्रेक के बाद। द इमरजेंसी प्रोविजंस आर कंटेंट इन पार्ट 18 ऑफ द कॉन्स्टिट्यूशन फ्रॉम आर्टिकल्स 352 to 360. These provisions enable the central government to meet any abnormal situation effectively. The rationality behind the incorporation of these provisions in the Constitution is to safeguard the sovereignty, unity, integrity, and security of the country, the democratic political system, and the Constitution. During an emergency, the central government becomes all powerful and the states go into the total control of the center. It converts the federal structure into a unitary one without a formal amendment of the Constitution. This kind of transformation of the political system from federal during normal times to unitary during emergency is a unique feature of the Indian Constitution. In this context, Dr. B.R. Ambedkar observed the Constituent Assembly that all federal systems, including American, are placed in a tight mold of federalism. No matter what the circumstances, it cannot change its form and shape. It can never be unitary. On the other hand, the Constitution of India can be both unitary as well as federal according to the requirements of time and circumstances. In normal times, it is framed to work as a federal system, but in times of emergency, it is so designed as to make it work as thought, though it was a unitary system. The Constitution stipulates three types of emergencies: an emergency due to war, external aggression, or armed rebellion. Article 352. This is popularly known as national emergency. However, the Constitution employs the aggression proclamation of emergency to denote an emergency of this type. An emergency due to the failure of the constitutional machinery in the states. Article 356. This is popularly known as President's Rule. It is also known by the two other names, state emergency or constitutional emergency. However, the Constitution does not use this word emergency for this situation. फिर क्या यूज़ करेगा ये? प्रेसिडेंट्स रूल, डेफिनेटली यही वाला यूज़ करेगा। फाइनेंशियल इमरजेंसी ड्यू टू ए थ्रेट टू द फाइनेंशियल स्टेबिलिटी और क्रेडिट ऑफ इंडिया, ये आर्टिकल 360 में है। Now, national emergency grounds of declaration. Under Article 352, the President can declare a national emergency when the security of India or part of it is threatened by war or external aggression or armed rebellion. It may be noted that the President can declare a national emergency even before the actual occurrence of war or external aggression or armed rebellion if he is satisfied that there is an imminent danger. The President can also issue different proclamations on grounds of war, external aggression, armed rebellion, or imminent danger thereof, whether or not there is a proclamation already issued by him and such proclamation is in operation. This provision was added by the 38th Amendment Act of 1975. When a national emergency is declared on the ground of war or external aggression, it is known as external emergency. On the other hand, when it is declared on the ground of armed rebellion, it is known as internal emergency. A proclamation of national emergency may be applicable to the entire country or only a part of it. The 42nd Amendment Act of 1976 enabled the President to limit the operation of a national emergency to a specified part of India. Originally, the Constitution mentioned internal disturbance as the third ground for the proclamation of a national emergency, but the expression was too vague and had a wider connotation. Hence, the 44th Amendment Act of 1978 substituted the words armed rebellion for internal disturbance. Thus, it is no longer possible to declare a national emergency on the ground of internal disturbance as was done in 1975 by the Congress government headed by Indira Gandhi. The President, however, can proclaim a national emergency only after receiving a written recommendation from the Cabinet. This means that the emergency can be declared only on the concurrence of the Cabinet and not merely on the advice of the Prime Minister. In 1975, the then Prime Minister Indira Gandhi advised the President to proclaim emergency without consulting her Cabinet. The Cabinet was informed of the proclamation after it was made as a fait accompli. The 44th Amendment Act of 1978 introduced this safeguard to eliminate any possibility of the Prime Minister alone taking a decision in this regard. The 38th Amendment Act of 1975 made the declaration of a national emergency immune from the judicial review, but this provision was subsequently deleted by the 44th Amendment Act of 1978. Further, in the Minerva Mills case 1980, the Supreme Court held that the proclamation of a national emergency can be challenged in a court on the ground of malafide or that the declaration was based on wholly extraneous and irrelevant facts and is absurd or perverse. Parliamentary approval and duration. The proclamation of emergency must be approved by both the Houses of Parliament with 1 month from the date of its issue. Originally, the period allowed for approval by the Parliament was for 2 months but was reduced by the 44th Amendment Act of 1978. However, if the proclamation of emergency is issued at a time when the Lok Sabha has been dissolved or the dissolution of the Lok Sabha takes place during the period of 1 month without approving the proclamation, then the proclamation survives until 30 days from the first sitting of the Lok Sabha after its reconstitution, provided the Rajya Sabha has in the meantime approved it. If approved by both the Houses of Parliament, the emergency continues for 6 months and can be extended to an indefinite period with an approval of the Parliament for every 6 months. This provision for periodical parliamentary approval was also added by the 44th Amendment Act 1978. Before that, the emergency, once approved by the Parliament, could remain in operation as long as the executive Cabinet desired. However, if the dissolution of the Lok Sabha takes place during the period of 6 months without approving the further continuance of emergency, then the proclamation survives until 30 days from the first sitting of the Lok Sabha after its reconstitution, provided the Rajya Sabha has in the meantime approved its continuation. Every resolution approving the proclamation of emergency or its continuance must be passed by either House of Parliament by a special majority, that is a majority of the total membership of that House and a majority of not less than 2/3 of the members of that House present and voting. This special majority provision was introduced by the 44th Amendment Act of 1978. Previously, such resolution could be passed by a simple majority of the Parliament. Revocation of proclamation. A proclamation of emergency may be revoked by the President at any time by a subsequent proclamation. Such a proclamation does not require the parliamentary approval. Further, the President must revoke a proclamation if the Lok Sabha passes a resolution disapproving its continuation. Again, this safeguard was introduced by the 44th Amendment Act of 1978. Before the amendment, a proclamation could be revoked by the President on his own, and the Lok Sabha had no control in this regard. The 44th Amendment Act of 1978 also provided that where 1/10 of the total members of the Lok Sabha give a written notice to the Speaker or to the President if the House is not in session, a special sitting of the House should be held within 14 days for the purpose of considering a resolution disapproving the continuation of the proclamation. A resolution of disapproval is different from a resolution approving the continuation of a proclamation in the following two respects. The first one is required to be passed by the Lok Sabha only, while the second one needs to be passed by the both Houses of Parliament. The first one is to be adopted by a simple majority only, while the second one needs to be adopted by a special majority. Okay. Effects of national emergency. A proclamation of emergency has drastic and wide-ranging effects on the political system. These consequences can be grouped into three categories: effect on the center-state relations, effect on the life of the Lok Sabha and State Assembly, and effect on the fundamental rights. Effect on the center-state relations. While a proclamation of emergency is enforced, the normal fabric of the center-state relations undergoes a basic change. This can be studied under three heads, namely executive, legislative, and financial. Executive. During a national emergency, the executive power of the center extends to directing any state regarding the manner in which its executive power is to be exercised. In normal times, the center can give executive directions to a state only on certain specified matters. However, during a national emergency, the center becomes entitled to give executive directions to a state on any matter. Thus, the state governments are brought under the complete control of the center, though they are not suspended. Legislative. During a national emergency, the parliament becomes empowered to make laws on any subject mentioned in the state list. Although the legislative power of the state legislature is not suspended, it becomes subject to the overriding power of the parliament. Thus, the normal distribution of the legislative power between the central and states is suspended. Though the state legislatures are not suspended, in brief, the constitution becomes unitary rather than federal. The laws made by parliament on the state subjects during a national emergency becomes inoperative 6 months after the emergency has ceased to operate. Notably, while a proclamation of national emergency is in operation, the president can issue ordinances on the state subjects also if the parliament is not in session. Further, the parliament can confer powers and impose duties upon the center or its officers and authorities in respect of matters outside the union list in order to carry out the laws made by it under its extended jurisdiction as a result of the proclamation of a national emergency. The 42nd Amendment Act of 1976 provided that the two consequences mentioned above, executive and legislative, extends not only to a state where the emergency is in operation but also to any other state. Financial. While a proclamation of national emergency is in operation, the president can modify the constitutional distribution of revenues between the center and the states. This means that the president can either reduce or cancel the transfer of finances from center to the state. Such modification continues till the end of financial year in which the emergency ceases to operate. Also, every such order of the president has to be laid before both the houses of the parliament. Effect on the life of Lok Sabha and State Assembly. While a proclamation of national emergency is in operation, the life of the Lok Sabha may be extended beyond its normal term 5 years by law of parliament for 1 year at a time for any length of time. However, this extension cannot continue beyond a period of 6 months after the emergency has ceased to operate. For example, the term of the 5th Lok Sabha 1971 to 1977 was extended 2 times by 1 year at a time. Similarly, the parliament may extend the normal tenure of a state legislative assembly 5 years by 1 year each time for any length of time during a national emergency, subject to a maximum period of 6 months after the emergency has ceased to operate. Effect on the fundamental rights. Article 358 and 359 describe the effect of a national emergency on the fundamental rights. Article 358 deals with the suspension of the fundamental rights guaranteed by Article 19, while Article 359 deals with the suspension of other fundamental rights except those guaranteed by Articles 20 and 21. These two provisions are explained below. Suspension of fundamental rights under Article 19. According to Article 358, when a proclamation of national emergency is made, the 6 fundamental rights under Article 19 are automatically suspended. No separate order for their suspension is required. While a proclamation of national emergency is in operation, the state is freed from the restrictions imposed by Article 19. In other words, the state can make any law or can take any executive action abridging or taking away the 6 fundamental rights guaranteed by Article 19. Any such law or executive action cannot be challenged on the ground that they are inconsistent with the 6 fundamental rights guaranteed by Article 19. When the national emergency ceases to operate, Article 19 automatically revives and comes into force. Any law made during emergency to have extent of inconsistency with Article 19 ceases to have effect. However, no remedy lies for anything done during the emergency even after the emergency expires. This means that the legislative and executive actions taken during emergency cannot be challenged even after the emergency ceases to operate. The 44th Amendment Act of 1978 restricted the scope of Article 358 in two ways. Firstly, the six fundamental rights under Article 19 can be suspended only when the national emergency is declared on the ground of war or external aggression and not on the ground of armed rebellion. Secondly, only those laws which are related with the emergency are protected from being challenged and not other laws. Also, the executive action taken only under such a law is protected. Suspension of other fundamental rights. Article 359 authorizes the President to suspend the right to move any court for the enforcement of fundamental rights during a national emergency. This means that under Article 359, the fundamental rights are as such they are not suspended but only their enforcement. The said rights are theoretically alive, but the right to seek remedy is suspended. The suspension of enforcement relates to only those fundamental rights that are specified in the presidential order. Further, the suspension could be for the period during the operation of emergency or for a shorter period as mentioned in the order, and the suspension order may extend to the whole or any part of the country. It should be laid before each House of Parliament for approval. While a presidential order is in force, the state can make any law or can take any executive action abridging or taking away the specified fundamental rights. Any such law or executive action cannot be challenged on the ground that they are inconsistent with the specified fundamental rights. When the order ceases to operate, any law so made to the extent of inconsistency with the specified fundamental rights ceases to have effect, but no remedy lies for anything done during the operation of the order even after the order ceases to operate. This means that these legislative and executive actions taken during the operation of the order cannot be challenged even after the order expires. The 44th Amendment Act of 1978 restricted the scope of Article 359 in two ways. Firstly, the President cannot suspend the right to move the court for the enforcement of fundamental rights guaranteed by Articles 20 to 21. In other words, the right to protection in respect of conviction for offences Article 20 and the right to life and personal liberty Article 21 remain enforceable even during emergency. Secondly, only those laws which are related with emergency are protected from being challenged and not other laws, and the executive action taken only under such a law is protected. Distinction between Articles 358 and 359. The differences between Articles 358 and 359 can be summarized as follows. Article 358 is confined to fundamental rights under Article 19 only, whereas Article 359 extends to all those fundamental rights whose enforcement is suspended by the presidential order. Article 358 automatically suspends the fundamental rights under Article 19 as soon as the emergency is declared. On the other hand, Article 359 does not automatically suspend any fundamental right. It only empowers the President to suspend the enforcement of the specified fundamental rights. Article 358 operates only in case of external emergency, that is, when the emergency is declared on the grounds of war or external aggression, and not in the case of internal emergency, that is, when the emergency is declared on the grounds of armed rebellion. Article 359, on the other hand, operates in case of both external emergency as well as internal emergency. Article 358 suspends fundamental rights under Article 19 for the entire duration of emergency, while Article 359 suspends the enforcement of fundamental rights for a period specified by the President, which may either be the entire duration of emergency or a shorter period. Article 358 extends to the entire country, whereas Article 359 may extend to the entire country or a part of it. Article 358 suspends Article 19 completely, while Article 359 does not empower the suspension of the enforcement of Articles 20 and 21. Article 358 enables the state to make any law or take any executive action inconsistent with fundamental rights under Article 19, while Article 359 enables the state to make any law or take any executive action inconsistent with those fundamental rights whose enforcement is suspended by the presidential order. There is also a similarity between Article 358 and Article 359. Both provide immunity from challenge to only those laws which are related with the emergency and not other laws. Also, the executive action taken only under such a law is protected by both. Declarations made so far. This type of emergency has been proclaimed 3 times so far, in 1962, 1971 and 1975. The first proclamation of national emergency was issued in October 1962 on account of Chinese aggression in the Nifa Northeast Frontier Agency, now Arunachal Pradesh, and was in force till January 1968. 6 साल. Hence, a fresh proclamation was not needed at the time of war against Pakistan in 1960. फाइव, अच्छा दो वार हो गया था. द सेकेंड प्रोक्लेमेशन ऑफ नेशनल इमरजेंसी was made in December 1971 in the wake of attack by Pakistan. Even when this emergency was in operation, a third proclamation of national emergency was made in June 1975. Both the second and third proclamations were revoked in March 1977. The first two proclamations, 1962 and 1971, were made on the ground of external aggression, while the third proclamation was made on the ground of internal disturbance. That is, certain persons have been inciting the police and armed forces against the discharge of their duties and their normal functioning. The emergency declared in 1975 internal emergency proved to be the most controversial. There was widespread criticism of the misuse of emergency power in the elections held to the Lok Sabha in 1977. After the emergency, the Congress party led by Indira Gandhi lost and the Janata Party came to power. This government appointed the Shah Commission to investigate the circumstances that warranted the declaration of an emergency in 1975. The Commission did not justify the declaration of the emergency, hence the 44th Amendment Act was enacted in 1978 to introduce a number of safeguards against the misuse of emergency provisions. President's rule. Grounds of imposition. Article 355 imposes a duty on the center to ensure that the government of every state is carried on in accordance with the provisions of the Constitution. It is the duty in the performance of which the center takes over the government of a state under Article 356 in case of failure of constitutional machinery in the state. This is popularly known as President's rule. It is also known as state's emergency or constitutional emergency. The President's rule can be proclaimed under Article 356 on the two grounds mentioned in Article 356 itself and another in Article 365. Article 356 empowers the President to issue a proclamation if he is satisfied that a situation has arisen in which the government of a state cannot be carried on in accordance with the provisions of the Constitution. Notably, the President can act either on a report of the governor of the state or otherwise too, even without the governor's report. Article 365 says that whenever a state fails to comply with or to give effect to any direction from the center, it will be lawful for the President to hold that a situation has arisen in which the government of the state can not be carried on in accordance with the provisions of the Constitution. Parliamentary approval and duration. A proclamation imposing President's rule must be approved by both the Houses of Parliament within 2 months from the date of its issue. However, if the proclamation of President's rule is issued at a time when the Lok Sabha has been dissolved or the dissolution of the Lok Sabha takes place during the period of 2 months without approving the proclamation, then the proclamation survives until 30 days from the first sitting of the Lok Sabha after its reconstitution, provided the Rajya Sabha approves it in the meantime. If approved by both the Houses of Parliament, the President's rule continues for 6 months. It can be extended for a maximum period of 3 years with the approval of the Parliament every 6 months. However, if the dissolution of the Lok Sabha takes place during the period of 6 months without approving the further continuation of the President's rule, then the proclamation survives until 30 days from the first sitting of the Lok Sabha after its reconstitution, provided the Rajya Sabha has in the meantime approved its continuance. Every resolution approving the proclamation of President's rule or its continuation can be passed by either House of Parliament only by a simple majority, that is a majority of the members of that House present and voting. The 44th Amendment Act of 1978 introduced a new provision to put restraint on the power of Parliament to extend the proclamation of President's rule beyond 1 year. Thus, it provided that beyond 1 year, the President's rule can be extended by 6 months at a time only when the following two conditions are fulfilled. A proclamation of national emergency should be in operation in the whole of India or in the whole or in a part of the state, and the Election Commission must certify that the general elections to the Legislative Assembly of the concerned state cannot be held on account of difficulties. A proclamation of President's rule may be revoked by the President at any time by a subsequent proclamation. Such a proclamation does not require the parliamentary approval. Consequences of President's rule. The President acquires the following extraordinary powers when the President's rule is imposed in a state. He can take up the functions of the state government and powers vested in the governor or any other executive authority in the state. He can declare that the powers of the state legislature are to be exercised by the parliament. He can take all other necessary steps, including the suspension of the constitutional provisions relating to any body or authority in the state. Therefore, when the president's rule is imposed in a state, the president dismisses by the state council of ministers headed by the chief minister. The state governor, on behalf of the president, carries on the state administration with the help of the chief secretary of the state or the advisors appointed by the president. This is the reason why a proclamation under Article 356 is popularly known as the imposition of president's rule in a state. Further, the president either suspends or dissolves the state legislative assembly. The parliament passes the state legislative bills and the state budget. When the state legislature is thus suspended or dissolved, the parliament can delegate the power to make laws for the state to the president or to any other authority specified by him in this regard. The parliament, or in case of delegation, the president or any other specified authority, can make laws conferring powers and imposing duties on the center or its officers and authorities. The president can authorize, when the Lok Sabha is not in session, expenditure from the state consolidated fund pending its sanction by the parliament, and the president can promulgate, when the parliament is not in session, ordinances for the governance of the state. A law made by the parliament or president or any other specified authority continues to be operative even after the president's rule. This means that the period for which such a law remains in force is not coterminous with the duration of the proclamation, but it can be repealed or altered or re-enacted by the state legislature. It should be noted here that the president cannot assume to himself the powers vested in the concerned state high court or suspend the provisions of the constitution relating to it. In other words, the constitutional position, status, powers and functions of the concerned state high court remain same even during the president's rule. Use of Article 356. Since 1950, the president's rule has been imposed on more than 125 occasions, that is on an average twice a year. Further, on a number of occasions, the president's rule has been imposed in an arbitrary manner for political or personal reasons. Hence, Article 356 has become one of the most controversial and most criticized provisions of the Constitution. Comparing national emergency and president's rule, so national emergency can be proclaimed only when the security of India or a part of it is threatened by war, external aggression or armed rebellion. Whereas president's rule, it can be proclaimed when the government of a state cannot be carried on in accordance with the provisions of the Constitution due to reasons which may not have any connection with war, external aggression or armed rebellion. Then, national emergency, during its operation, the state executive and legislature continue to function and exercise the powers assigned to them under the Constitution. Its effect is that the center gets concurrent powers of administration and legislation in the state. During president's rule, the state executive is dismissed and the state legislature is either suspended or dissolved. The president administers the state through the governor and the parliament makes laws for the state. In brief, the executive and the legislative powers of the state are assumed by the center. Then, during national emergency, the parliament can make laws on the subjects enumerated in the state list only by itself, that is, it cannot delegate the same to any other body or authority. And under the during president's rule, the parliament can delegate the power to make laws for the state to the president or to any other authority specified by him. So far, the practice has been for the president to make laws for the state in consultation with the members of parliament from the state. Such laws are known as President's Acts. Then, national emergency, there is no maximum period prescribed for its operation. It can be continued indefinitely with the approval of parliament for every 6 months. And president's rule, there is a maximum period prescribed for its operation, that is 3 years. Thereafter, it must come to an end and the normal constitutional machinery must be restored in the state. Then, national emergency, under this, the relationship of the center with all the states undergoes a modification. President's rule, under this, the relationship of only one state, only the state under emergency with the center undergoes a modification. Then, national emergency, every resolution of parliament approving its proclamation or its continuance must be passed by a special majority. President's rule, every resolution of parliament approving its proclamation or its continuance can be passed only by a simple majority. National emergency affects fundamental rights of the citizens, and state emergency or president's rule has no effect on fundamental rights of the citizens. Then, national emergency, Lok Sabha can pass a resolution for its revocation, and there is no such provision in case of president's rule. It can be revoked by the president only on his own. For the first time, the President's rule was imposed in Punjab in 1951. By now, almost all the states have been brought under the President's rule once or twice or more. The details in this regard are given table. Okay, when general elections were held to the Lok Sabha in 1977 after the internal emergency, the ruling Congress party lost and the Janata Party came to power. The new government headed by Modesti Desai imposed President's rule in 9 states where the Congress party was in power, on the ground that the assemblies in those states no longer represented the wishes of the electorate. When the Congress party returned to power in 1980, it did the same in 9 states on the same ground. In 1992, the president's rule was imposed in 3 BJP ruled states, Madhya Pradesh, Himachal Pradesh and Rajasthan, by the Congress party on the ground that they were not implementing sincerely the ban imposed by the center on religious organizations. In a landmark judgment in Bomai case 1994, the Supreme Court upheld the validity of this proclamation on the ground that secularism is a basic feature of the Constitution. But मतलब ये religious वाला matter बहुत दिनों से है. But the court did not uphold the validity of the imposition of the president's rule in Nagaland in 1988, Karnataka in 1989 and Meghalaya in 1991. Dr. B.R. Ambedkar, while replying to the critics of this provision in the Constituent Assembly, hoped that the drastic power conferred by Article 356 would remain a dead letter and would be used only as a measure of a last resort. He reserved, the intervention of the center must be deemed to be barred because that would be an invasion on the sovereign authority of the province state. That is a fundamental proposition which we must accept by reason of the fact that we have a federal constitution. That being so, if the center is to interfere in the administration of the provincial affairs, it must be under some obligation which the constitution imposes upon the center. The proper thing we ought to expect is that such articles will never be called into operation and that they would remain a dead letter if at all they are brought into operation. I hope the president who is endowed with this power will take proper precautions before actually suspending the administration of the province. However, the subsequent events show that what was hoped to be a dead letter of the constitution has turned to be a deadly weapon against a number of states, governments and legislative assemblies. In this context, H.B. Kamath, a member of the Constituent Assembly, commented a decade ago, Dr. Ambedkar is dead and the articles are very much alive. Scope of judicial review. The 38th Amendment Act of 1975 made the satisfaction of the President in invoking Article 356 final and conclusive, which could not be challenged in any court on any ground. But this provision was subsequently deleted by the 44th Amendment Act of 1978, implying that the satisfaction of the President is not beyond judicial review. In Bomai case 1994, the following propositions have been laid down by the Supreme Court on imposition of President's rule in a state under Article 356. The presidential proclamation imposing President's rule is subject to judicial review. The satisfaction of the President must be based on relevant material. The action of the President can be struck down by the court if it is based on irrelevant or extraneous grounds or if it was found to be malified or perverse. Burden lies on the center to prove that a relevant material exists to justify the imposition of the President's rule. The court cannot go into the correctness of the material or its adequacy, but it can see whether it is relevant to the action. If the court holds the presidential proclamation to be unconstitutional and invalid, it has power to restore the dismissed state government and revive the state legislative assembly if it was suspended or dissolved. The state legislative assembly should be dissolved only after the parliament has approved the presidential proclamation. Until such approval is given, the president can only suspend the assembly. In case the parliament fails to approve the proclamation, the assembly would get reactivated. Secularism is one of the basic features of the constitution. Hence, a state government pursuing anti-secular politics is liable to action under Article 356. The question of the state government losing the confidence of the legislative assembly should be decided on the floor of the house, and until that is done, the ministry should not be unseated. Where a new political party assumes power at the center, it will not have the authority to dismiss ministries formed by other parties in the states. The power under Article 356 is an exceptional power and should be used only occasionally to meet the requirements of special situations. Cases of proper and improper use. Based on the report of the Sarkaria Commission on Center-State Relations 1988, the Supreme Court in Bomai case 1994 enlisted the situations or the exercise of power under Article 356 could be proper or improper. Imposition of president's rule in a state would be proper in the following situations: where after general elections to the assembly no party secures a majority, that is hung assembly; where the party having a majority in the assembly declines to form a ministry and the governor cannot find a coalition ministry commanding a majority in the assembly; where a ministry resigns after its defeat in the assembly and no other party is willing or able to form a ministry commanding a majority in the assembly; where a constitutional direction of the central government is disregarded by the state government; internal subversion, where for example a government is deliberately acting against the constitution and the law or is fomenting a violent revolt; physical breakdown, where the government willfully refuses to discharge its constitutional obligations, endangering the security of the state. The imposition of president's rule in a state would be improper under the following situations: where a ministry resigns or is dismissed or losing majority support in the assembly and the governor recommends imposition of president's rule without proving the possibility of forming an alternative ministry; where the governor makes his own assessment of the support of a ministry in the assembly and recommends imposition of president's rule without allowing the ministry to prove its majority on the floor of the assembly; where the ruling party enjoying majority support in the assembly has suffered a massive defeat in the general elections to the Lok Sabha, such as in 1977 and 1980; internal disturbances not amounting to internal subversion or physical breakdown; maladministration in the state or allegations of corruption against the ministry or stringent financial exigencies of the state; where the state government is not given prior warning to rectify itself except in case of extreme urgency leading to disastrous consequences; where the power is used to sort out inter-party problems of the ruling party or for a purpose extraneous or irrelevant to the one for which it has been conferred by the Constitution. Financial emergency. Grounds of declaration. Article 360 empowers the President to proclaim a financial emergency if he is satisfied that a situation has arisen due to which the financial stability or credit of India or any part of its territory is threatened. The 38th Amendment Act of 1975 made the satisfaction of the President in declaring a financial emergency final and conclusive and not questionable in any court on any ground, but this provision was subsequently deleted by 44th Amendment Act of 1978, implying that the satisfaction of the President is not beyond judicial review. Parliamentary approval and duration. A proclamation declaring financial emergency must be approved by the both houses of Parliament within 2 months from the date of its issue. However, if the proclamation of financial emergency is issued at a time when the Lok Sabha has been dissolved or the dissolution of the Lok Sabha takes place during the period of 2 months without approving the proclamation, then the proclamation survives until 30 days from the first sitting of the Lok Sabha after its reconstitution, provided the Rajya Sabha has in the meantime approved it. Once approved by both the houses of Parliament, the financial emergency continues indefinitely till it is revoked. This implies two things: there is no maximum period prescribed for its operation, and repeated parliamentary approval is not required for its continuation. A resolution approving the proclamation of financial emergency can be passed by either house of Parliament only by a simple majority, that is, a majority of the members of that house present and voting. A proclamation of financial emergency may be revoked by the President at any time by a subsequent proclamation. Such a proclamation does not require a parliamentary approval. Effects of financial emergency. The consequences of the proclamation of financial emergency are as follows. The executive authority of the center extends to the giving of a directions to any state to observe such canons of financial propriety as may be specified in the directions, and such other directions to any state as the President may deem necessary and adequate for the purpose. Any such direction may include a provision requiring the reduction of salaries and allowances of all or any class of persons serving in the state, and the reservation of all money bills or other financial bills for the consideration of the President after they are passed by the legislature of the state. The President may issue directions for the reduction of salaries and allowances or of all or any class of persons serving the Union, and the judges of the Supreme Court and the High Court. Thus, during the operation of a financial emergency, the center acquires full control over the states in financial matters. H.N. Kunjru, a member of the Constituent Assembly, stated that the financial emergency provisions pose a serious threat to the financial autonomy of the states. Explaining the reasons for their inclusion in the Constitution, Dr. B.R. Ambedkar observed in the Constituent Assembly. This article more or less follows the pattern of what is called the National Recovery Act of the United States passed in 1933, which gave the President power to make similar provisions in order to remove the difficulties, both economical and financial, that had overtaken the American people as a result of the Great Depression. No financial emergency has been declared so far, though there was a financial crisis in 1991. Criticism of the emergency provision. Some members of the Constituent Assembly criticized the incorporation of emergency provisions in the Constitution on the following grounds: the federal character of the Constitution will be destroyed and the Union will become all-powerful. The powers of the state, both the Union and the units, will entirely be concentrated in the hands of the Union executive. The president will become a dictator, the financial autonomy of the state will be nullified, fundamental rights will become meaningless, and as a result, the democratic foundations of the Constitution will be destroyed. Thus, H.B. Kamath observed, I fear that by this single chapter we are seeking to lay the foundation of a totalitarian state, a police state, a state completely opposed to all the ideals and principles that we have held aloft during the last few decades, a state where the rights and liberties of millions of innocent men and women will be in continuous jeopardy, a state where if there be peace, it will be the peace of the grave and the void of the desert. It will be a day of shame and sorrow when the president makes use of these powers having no parallel in any constitution of the democratic countries of the world. Katie Shah described them as a chapter of reaction and retrogression. I find one cannot but notice two distinct currents of thought underlying and influencing throughout the provisions of this chapter: to arm the center with special powers against the units and to arm the government against the people. Looking at all the provisions of this chapter particularly and scrutinizing the powers that have been given in almost every article, it seems to me the name only of liberty or democracy will remain under the Constitution. T.T. Krishnamachari feared that by means of these provisions the president and executive would be exercising a form of constitutional dictatorship. H. N. Kunjru opined that the emergency financial provisions pose a serious threat to the financial autonomy of the states. However, there are also protagonists of the emergency provisions in the Constituent Assembly, that Sir Aladi Krishna Swamy Iyer labeled them as the very life breath of the Constitution. Mahavir Tyagi opined that they would work as a safety valve and thereby help in the maintenance of the Constitution. While defending the emergency provisions in the Constitution Assembly, Dr. B.R. Ambedkar also accepted the possibility of their misuse. He observed, I do not altogether deny that there is a possibility of the articles being abused or employed for political purposes. So यहाँ पर दिया गया है कि कौन सी स्टेट के ऊपर कब ये प्रेसिडेंट रूल लगा था। जैसे कि बताया कि 182 केसेस हुआ था, कुछ ऐसा स्टैटिस्टिक था ना, तो वो वाला। चलिए, तो यहाँ पर आर्टिकल का लिस्ट है। तो यहाँ पर हमारा ख़त्म होता है आज का टारगेट। तो ये 3 चैप्टर हमने कंप्लीट किया इस वीडियो में: DPSP, देन फंडामेंटल ड्यूटीज एंड नेक्स्ट इज इमरजेंसी प्रोविजंस। तो थैंक्स फॉर वॉचिंग, थैंक्स फॉर लिसनिंग, गुड नाइट।